I think I'm letting people in.
You are.
Okay, good. Okay. Welcome those who are here early. We're looking forward to presenting to you this evening. So did you get your estimate, Lisa? It's all good?
Yeah. You shop around. It's amazing how the differences, what the differences can be.
The most important thing is that they show up and they finish.
Oh, yeah. Yeah, well, this one comes with recommendations, several.
Yeah, that's the way you've got to go.
Mm-hmm.
And just as a reminder, because MBBA records everything, sometimes the programs are more popular on demand afterwards than they are on the evening. So welcome those of you who are joining us. We're going to get started in a couple minutes. I didn't test out the screen share. Let me do that real quickly. Are you able to see it?
Yes.
Okay. Okay, 1 minute to go. Welcome those joining us. We're about to get started in a moment or so. Good evening. On behalf of the Metropolitan Black Bar Association's ADR section, we would like to welcome everybody this evening to our panel, part 2 of our panel series on arbitration. This is Arbitration Nuts and Bolts, A to Z, part 2. And as a reminder, there are 2 CLE credits that will be awarded in connection with this program. The CLE code will be stated verbally towards the end of the program. So just to let you know, to be alert to that. The ADR section would very much like to thank the following other sections of the Metropolitan Black Bar Association for co-sponsoring this program. Those are the civil litigation section, the labor and employment section, and the solo and small firm section. We thank all those sections, their leadership and their members for your co-sponsorship of this program. I'm going to switch to a PowerPoint and keep talking, so there might be a quick delay as I get the PowerPoint out. So I would like to welcome the panel and give you a brief introduction of them. We first have with us William Crosby Jr., goes by Bill. Bill is Vice President, Associate General Counsel, and Managing Attorney for Interpublic Group, which is a New York-based advertising and marketing company. It has over 50,000 employees worldwide. And Bill has been with the company since 2002. He oversees global litigation. and he is the head of the Latin American legal team and chief of staff for the legal department. Prior to being at Interpublic, Bill was an attorney, an associate attorney with Davis Polk Wardell, and also with K. Collier Booz. Since 2009, Bill has been an arbitrator with the American Arbitration Association and their divisions of ICDR and ICC on ICC matters, commercial matters, intellectual property, complex business matters, restaurant, hotel management, franchising, a number of different commercial business issues. Bill is a proud graduate of Yale College and Stanford Law School. In addition to Bill, we have joining us today, Lisa D. Love. Lisa is the managing partner of Love and Long, LLP. This is a boutique law firm with offices in Newark, New Jersey, and New York and Philadelphia. Lisa's background is in corporate finance. She worked at a major Madison Avenue, New York law firm. And she has also been chief legal counsel to not one, but 2 urban municipalities. She has been lead outside counsel to the United States Department of the Treasury. We better pay our taxes. Her background is focused on, or her practice is focused on commercial transactions, contracts, corporate finance, mergers and acquisitions, real estate, leasing, redevelopment, and public agency transactions. Lisa is also a mediator and an arbitrator. She arbitrates with and mediates with the organizations FINRA and the American Arbitration Association. Moderating the panel today, I will be handing off to my MBBA ADR section co-chair, Lauren Jones. She holds many important roles in life, including being the ADR coordinator for the New York City Surrogates Courts. Lauren?
Thank you, Jill. And thank you all for coming to part 2 of our webinar. We're very excited to have you here. Very esteemed guests, as you just heard, Lisa Love and Bill Crosby, who are going to walk us through. We heard last time in part 1 about how to get ready to prepare for an arbitration and everything it takes. And now we're actually here, we're at the table, we're at the hearing, and we're going to hear what that means, how does this go, and what is actually going through the mind of the arbitrators. So we're going to get kicked off. Bill, we're going to start off with, how do arbitrators and counsels prepare for these evidentiary hearings? And especially in light of, I guess we're in post-COVID age. I hear New York is opening again, dropping the restrictions, video versus in person, and how do they differ, and how does one prepare for these things?
Okay, great. Well, thank you. And I'm very happy to be here. Thank you for all of you who are joining us today. And thank you for inviting me to speak. So you already had a discussion in your first part about the evidentiary hearing, and that really is so important in terms of setting the stage for an efficient, effective hearing, where you go through the various aspects that you get lead time for all the different parts that'll have to come together to make for a successful hearing, evidentiary hearing. So I'm not going to go over that again. You already had a discussion on that, but I can't overstate the importance of the evidentiary hearing, the preliminary hearing, and the steps that lead to that. So now you've done the preliminary hearing, everything's still on track. You've got hearings that are scheduled to happen imminently within a week, a few days. So what is the arbitrator doing at this point to make sure that these hearings go off well? The one thing to keep in mind throughout all of our discussion tonight is that the arbitrator is really in charge with making sure that the arbitration proceeds in an efficient, effective way. All right, it's your job as arbitrator to make sure that happens, just like it's the job of a judge in a courtroom to make sure that the court proceedings, it's not the lawyer's job to make sure that the trial goes well. It's the judge's job to make sure that there's a presence, that there's direction, and that everybody is pulling together to make it work and make it work well. So same thing here in an arbitration. So in these days with remote hearings, it was a lot easier when people just showed up at a hearing site, and that's probably going to continue to happen, at least to a certain extent. But now with evidentiary hearings happening through often through remote means, or at least some witnesses testifying or counsel appearing, sometimes even arbitrators appear. If it's a group of arbitrators, you might have one that appears remotely. It's really important to make sure, and this is basic stuff, but it's very, very important, make sure the technology is working, right? So we do tech checks beforehand to make sure that everyone's video is working properly, that we can hear the witnesses, we can hear counsel, the court reporter, that you may very well have a court reporter who is presenting documents. How are those documents appearing on screen? How's screen sharing work? So all of these things that are so basic. Just before this, we started this session, we did a screen share test to make sure that everything was working. We made sure we could hear one another. Same thing in a hearing. So those basic technological checks to make sure that you're not going to discover problems on the first day of the hearing, and it's going to require you a half a day to resolve those. You take an hour, maybe a week beforehand, to bring everybody together and make sure that everything is working the way it's supposed to work. Another part of the preparation for the evidentiary hearing is asking counsel to submit pre-hearing briefs and reviewing those briefs as the arbitrator. Now, in my own practice as an arbitrator, I don't usually require parties to make pre-hearing submissions, particularly in small cases, where the case looks like it's manageable. I don't want to require counsel to, have additional fees preparing briefs, so that I can review those in advance of the hearing. The hearing will probably be in a small enough matter, straightforward, that we can follow it. There'll be an opening, and it'll be pretty linear, and we'll sort of stick to that. But a lot of times the hearings actually become, there are many issues. There are some complicated issues that are being addressed. And just for efficiency's sake, it a lot of times makes sense to ask the parties to put things down in writing in terms of what they're expecting to present, giving a preview of their arguments, a preview of the claimant's case, a preview of the respondent's case, and just claimant and respondent are the terms that are used in arbitration. It's not plaintiff and defendant. The plaintiff is the claimant, and the defendant is the respondent. And it's just the way arbitration is. It's the language of arbitration. But I want to know, in any case that's not super simple, where it's just a one-issue case, I want to be able to focus on the real issues so that I have a roadmap as we're going through the hearings. It's also a very useful tool to focus counsel, because I don't want counsel just rambling and sort of presenting all these different arguments during the hearing. I like counsel to have thought about how they want to order their arguments, and I can kind of hold them to that as we go through the hearing. So it's a very useful technique for me and for counsel to really sort of focus on what we're going to do, have it laid out in an organized way, and then we can almost use it, not as a checklist, but you can use it sort of as a benchmark to kind of make sure that you're staying where you're supposed to stay. There aren't sort of crazy arguments that are being thrown out that had not been part of any prior discussion, and we can really stay on track, because you don't want hearings to sort of spiral and become, go on days and days or hours and hours longer than necessary. We really want, everyone's paying for this. The clients are paying for my time as an arbitrator. They're paying for their counsel. So, it really is incumbent on me to make sure as the arbitrator that no one's time and money are being wasted. And so I'll do what I can to make sure that happens. Just one other point on the review of these briefs. That's a central job of the arbitrator. I mean, if I don't review those briefs very carefully and make sure that I understand exactly what's being said from both sides, I am contributing potentially to further delay, and I don't want to do that. So I take a lot of time. I read them very carefully. I read the cases that are submitted, all of the arguments, and this is all before the case, so that nothing's been proved yet. But I definitely use it as a way to sort of see how things are going to be presented during the hearing. Next point is, Lauren, should I go on, or just did you want to stop me there?
Well, I actually have a question. I will confess to the audience, I am not an experienced arbitrator, so I am learning with a lot of you guys as well. So some of the questions I may ask, and you may have the same ones. you said that that's not necessarily a requirement to submit pre-hearing briefs, and so that's helpful. But you definitely laid out a lot of advantages to submitting them. I mean, you personally, as an arbitrator, use them as a roadmap. Litigators can find them helpful as a roadmap for themselves. So 2 questions on that. 1, are the pre-hearing briefs shared with the other side? And 2, is there a disadvantage to any party if one party elects to submit one and the other party decides not to?
Generally, the first question, yes, generally they're shared with the other side. I've had a couple of instances where they were not, but that's unusual, and there were unusual circumstances. But I think it's best for everybody to see what everybody's saying about the case, so they should be shared. They're usually due like the day before the hearing. I just want to make sure that I have them in advance. I'll look at them the night before. I don't need a week. I just need, I will reserve that evening to go through. They're usually not terribly long. They're not 50, 60, 70 page documents. I often put a page limit, give me under 20 pages, 15 pages, whatever seems appropriate, maybe even 10. Just really, so they're not rambling and writing, but really focusing on, here's my case, here's my defense. So when your second question is a really good one in terms of, is there a disadvantage? Because I don't require it, I've never had an instance where one party has taken me up on the opportunity to present and the other party did not. I would encourage the party that was thinking about not doing that to change their mind and actually, submit it. Because, I mean, if I'm offering that opportunity to one, it really does give that party an advantage if they're the only one to sort of crystallize their arguments, present them very neatly, and have me focused on that. If that happens, I've read one side's briefs and I show up at the hearing with a very good sense of one side's arguments, and I'm waiting to hear the other side's. So, I wouldn't tell a party you couldn't do that if they said, look, I know the other side is submitting these briefs, but I just don't want to do it. But I would really encourage them very strongly to do it. And I'd make it clear, you don't have to write, a book. You really just, a few pages would be sufficient. I don't want you to spend a lot of time and money on this, but I think it would help you and me to really sort of lay out what you're proposing to present at the hearings.
Okay, so moral of the story is if the arbitrator gives you the opportunity to have a say pre-hearing and your adversary is doing it, it behooves you to also make some sort of modicum of submission to at least layer the playing field and get your point across as well.
Right, and if you don't believe that when the arbitrator is suggesting very strongly that you change your mind, it definitely behooves you to do it, because I mean that's your second chance. Don't blow your second chance.
Right. Okay, and so can you walk us through how those same lawyers that are thinking about how they prepare their pre-hearing brief, how they prepare their clients and their witnesses for the ultimate hearing that's going to follow the submission of those briefs?
Yeah, so I mean, this is a really interesting thing. The real question is sort of, do you prepare your witness differently for an arbitration than you do for court proceedings? And my answer to that is generally not. I mean, I think that they're very similar. The difference is you don't, instead of a person in a black robe sitting at the top presiding over it, you have, a person in business attire or maybe a group of people in business attire sitting, in a conference room or presiding. There is not strict adherence to the rules of evidence and the rules of procedure. But aside from that, pretty much everything's the same. You have to present very clear arguments. Even though we're not bound by strict rules, there are rules, right? Hearsay, we're not bound by strict hearsay rules, but we're not going to let you come in and say, oh yeah, so-and-so told me that so-and-so heard from so-and-so down the street 2 days ago, that, it just becomes ridiculous at a certain point. There are limits to what we will allow and what's appropriate. So the lawyer should be making clear to the client, to their own client, that, there's a formality of the proceeding, notwithstanding the absence of a black robe, that they should present very clearly, should explain how things are going to work, which is that the lawyer will ask the questions first on direct examination, and the lawyer for the other side will have the opportunity to cross. And the lawyer will sit there and have an opportunity to object. And the arbitrator is the person who will resolve those issues and objections and make rulings on those. So clear communication with the client, making sure they understand the process. In the remote era, making sure that everyone, this sort of relates to the tech check, but just making sure that where people are, you know what access to technology they're going to have, who's going to be in the room, You've communicated with the other side to make sure that everyone's on the same page about where witnesses will be testifying, how they'll be testifying. Now that we've gotten past the worst of the pandemic, will you show up at the hearing room, or will you appear on a screen? And so as long as everyone is clear on exactly how that process is going to happen, that'll help for efficient proceedings. We don't want to have to spend a half an hour working these logistics out at the start of the hearing. I like to start my hearings by saying, are there any issues? Are we ready to go? And hopefully no one has any issues, and we can jump right into the start of the evidentiary hearing.
Awesome. That's very helpful. And that really does set the stage for what happens before you get into the actual hearing in terms of what documents are required, how arbitrators think about the submission of those documents, how they're distributed, and the kind of bar, if you will, for the presentation of evidence. So let's switch gears. Let's move on to the actual hearing, the evidentiary hearing. Who are these people that begin to make these decisions? We've heard panels thrown around. We've heard, maybe some people have heard the word chair. Lisa, can you kind of walk us through who are these arbitrators? Are they always one person? Is it three people? Is it something else? And how do we get started with the actual hearing? You can just unmute yourself.
Yes. So the evidentiary hearing and the persons who are arbitrators in the hearing generally is determined by the arbitration agreement. The arbitration agreement may say that it will be one person, a one-person panel. It may say there be three people. If there are three, they may say that the respondent chooses one, the claimant chooses another, and the two of them choose. There are very different ways of how you come up with who the panel will be. And you should also note that there are sometimes decisions on the documents. So there's not necessarily always an in-person hearing. So in some of the smaller cases, the parties may have decided, or it may have been in the arbitration agreement, especially when in consumer matters where a person signs what I call a contract of adhesion, which basically is a contract that was prepared by a corporation or an entity, and there's really no negotiation of that. Oftentimes, those type of agreements will have requirements that there be a decision on the documents. And in that situation, documents are submitted, and an arbitrator, generally one arbitrator in a document submission, decides the case basically only on the documents. And if they have any questions, they can send out supplemental questions to the parties and have them respond. But that is another way to do it. But in terms of the hearing itself, well, let me just start off. Thank you for inviting me to speak today. I appreciate this informal but informative process. I know that with arbitrations, it's a lot of learning on the job. I mean, it's almost like a learning on the job training. So oftentimes you'll get very smaller cases, and as you develop your skills, your case load and complexity will increase. If you are interested in becoming an arbitrator, I would suggest that you participate in some of the moot arbitration competitions that are all around New York. All the law school has them. It'll give you an opportunity to really just have some moot arbitration experience on how they're conducted. And it's a really, it's been helpful for me. I've traveled different places, even international, doing those type of competitions, and it's been really helpful. The other thing with respect to arbitration and arbitrators, you have to be able to make a decision. If you cannot make a decision, then probably arbitration is not something that you should pursue. The ability to make a decision based upon the evidence is critical. If you're wishy-washy with that, if you can't make a decision, don't be an arbitrator. But in terms of the hearing itself, there are some similarities, but there are a lot of differences between arbitration and a litigation. For instance, obviously there's no trial. Secondly, arbitrators tend to have specialized experience in the industry. For instance, as as it was indicated, I have finance experience and acquisition experience. So generally, I'm not going to be an arbitrator in a labor matter. I'm not going to be an arbitrator in an employment matter. Unlike some judges, not all, but some have a very general civil background and may not have the specialized expertise in one particular area, which arbitrators do. So you almost have to approach arbitrators a little bit differently. You can't approach them like they're blank slates or even like you're approaching a jury, because they have a lot of specialized knowledge and you expect them to bring that knowledge to the table, and it's part of their selection process. So when an arbitrator is selected, a lot of their writings are looked at, a lot of their prior experience, if some of their cases are published, the counsel will look at those type of things to determine who they're going to select. The other thing is, as Bill mentioned, there's no real formal rules of evidence. And for me, and I think that's great, and probably for others who are non-litigators, I'm not a litigator, but I can still be a great arbitrator. Because I don't have to know the formal federal rules of civil procedure, but I do know, common sense, what comes in, what shouldn't, what is admissible, what's not admissible, what's irrelevant, what's material, what the privileges are. I mean, as long as you have a basic understanding of that, you don't have to really be very, very concerned that you don't know formal rules of evidence. And the other thing with respect to arbitrations is that you really give up your right to appeal generally, I'll say generally with a caveat, on a substantive law basis. So if you think that the arbitrator sort of didn't get it, oftentimes it's very difficult to appeal that kind of decision or that kind of award. So that's why it's so critical when you select an arbitrator that you sort of understand what their philosophy is, what they've done in the past. So Bill talked about, the date, time, place of hearing. That's all established generally in the preliminary hearing. He also talked about location and the fact that now a lot of stuff is on Zoom and a lot of things are virtual. And that's our new normal. And, I guess that to some extent we may go back to some, and we probably will go back to some level of in-person arbitrations. But I believe that due to like the cost involved and the cost savings, like a lot of people will never go back to work in their offices, there will be some continuation of virtual hearings. So you need to be up on how those occur, how to make them happen. If you're working with an arbitral institute, then they will have processes and people who will set up the Zoom for you and the share screen and the breakout rooms for the witnesses and holding people in the waiting room and all those type of things that you need to do to have a virtual hearing. So the other thing that I want to talk about is the role of the chair and the role of the panel in terms of how evidence is presented and who makes the determination. So the chair really is the principal decider of a lot of the evidentiary issues, unless you all agree otherwise. Sometimes the chair may ask for input from his what we call wings, the people sitting on each side of him or her, for assistance in making a decision on the evidence. But generally, the role of the chair is really to guide the process, keep it going, keep everybody on schedule, make evidentiary determinations. When I have an arbitration, I tend to try to set up a schedule, especially if somebody, when we have a preliminary hearing, we say, well, how many days do you think it'll take to hear this matter? And based upon what the parties say, I try to allocate the time to them. And especially if you're an international, they may even be using what we call as a chess clock. So if a party has been allocated a certain amount of hours to present his case, there is someone keeping up with that time. So once you hit your time period, you have to wrap it up based upon the rules that you have agreed to abide by. But generally, I give certain period of time for, the presentation of the case in chief, if you will. We also build in schedule breaks, and we build in when lunch is. I mean, sounds a little tedious, but it's important so people understand in the beginning of the session how things will go. And oftentimes, maybe somebody may want to switch the time for the break or whatever. The other thing that you may come up come up with is somebody may need a break that wasn't scheduled, and how do you handle that? And I absolutely give everybody the break they need. People need a comfort break, let's break. We don't even, if somebody raises their hand and they need that, that happens. So before we even get to the hearing, and sometimes after the hearing, and maybe sometimes in the breaks of the hearing, the issue of ex parte communications comes up. And that's an important issue, because really you're not supposed to have ex parte communications with the parties. And even in FINRA training, if they tell you, if you're in the elevator or you go in the bathroom and one of the counsel is in there, don't say nothing. That's how they train. But it's important that you don't have ex parte communications, because it has the ability to sort of have an impact on whether or not your award can be vacated. So when I say ex parte communications, I mean, like if you copy, send something to the arbitrators, you have to also send the same thing to the opposing counsel. If you have conversations with the arbitrators, you can't exclude opposing counsel. If you copy an arbitrator on if an arbitrator sends out correspondence, they have to send out correspondence to all the parties.
Lisa, can I ask, if you're an arbitrator and you get that ex parte communication from one side, what do you do?
Well, in that situation, then you make sure that you direct them to also send that communication to the opposing side. And maybe you even ask them, have they done that, if it's not clear from what you have. And I think it's very interesting about the ex parte communications. And when I was looking at this issue, courts are hesitant, even in situations where you would think that they would vacate the order. They're hesitant sometimes to overturn an award based upon ex parte communications, but you do not want to be the test case. So for instance, there is, for example, here's one. During the course of a hearing, it became evident that one or more of the panelists had tried to unsuccessfully track down one of the individuals in the dispute. I mean, on his own, he decided he was going to try to track down one of the parties. He wasn't able to do it, but the losing counsel found out about it and said it was a violation and tried to get the award overturned. So what do you think? Did the court overturn it when it was brought to them, or did they, enforce the award notwithstanding this ex parte investigation? And the result is the court said that the losing party had the burden of proof to prove that the communication took place, and they could not meet its burden of proof, so they did not overturn that award. And the other thing that goes to, another example goes to how serious or informal the process is. In one instance, there was an attorney who liked to joke, an arbitrator who had a joking sort of informal nature. And so there were conversations between the arbitrator and a counsel about where they would sit in a crowded hearing room. And believe it or not, the losing counsel raised that as an issue, as an ex parte communication, and they tried to have the award overturned, but they were not successful. And one more example. And this one is more egregious. And this case is old too. I think this was like back in 1952, but there was a panel and there was testimony by the claimant, and they excluded the respondent from the room for a half an hour while they took the testimony. In that situation, they considered that was an ex parte communication between the arbitrators and the counsel, and that they ruled that, and the claimant itself, and they ruled that was ex parte communications, and they overturned that verdict. not verdict, they had overturned that award. So it's real important that you be conscious of ex parte conversations and communications, and you try not to have that happen. It becomes a little bit more difficult. Like when you're dealing with an institution, it's less likely to happen because you sort of have an intermediary between you. The institution basically, you know, serves as the gatekeeper and keeps those kind of communications for the most part separate. All communications go to the administrator. Administrator sends them to you. You send the communications to arbitrator. I'm sorry, to the administrator as an arbitrator, and the administrator sends them out to the parties. It becomes a little bit more difficult, and there are arbitrations where, you know, you're not going through these formal institutions. They're private party arbitrations. So parties will get together and they will select the arbitrator that's not on AAA, CPR, FINRA, none of that, the JAMS, none of that. They will decide, you know, we want, I don't know, one of my favorite mediators, he probably is not, I don't know if he does arbitration. We want Kenneth Feinberg to be the arbitrator in this case. And what happens? You know, they go to him directly. Ken has enough experience so that this ex parte communication is not going to happen. But assuming in that situation, how do you handle that when somebody calls you and says, you know, I need to reschedule, can we have a postponement? I mean, you have to make sure that you pull in the other counsel to those type of conversations and communications. So, you know, that's real important that you be cognizant of that, because again, you never want to be the test case. You do not want your order turned over. And there are things that you can do that will really make that, eliminate that possibility. So, you know, we have, as most proceedings, there's an opening statements from the parties, presentation of witnesses, presentation of evidence, you know, cross examinations. You'll have presentation of your experts and cross-examination. And if there's any counterclaims that have been presented, then there will be a whole proceeding on the counterclaims. One thing that, I'm sorry, go ahead. Go ahead.
I was just curious to take you back one step and then maybe move you one step forward also. You spoke about the role of the chair
Right.
and the panel. So can you explain specifically what the role of the chair is and how that differs from the panel, A? And then B, can you explain or just answer, can somebody choose the chair, or is that something that's chosen amongst the panel once the panel has been selected?
So the role of the chair really is, he or she really is controlling the process. They're the person who, you know, similar to the judge in terms of controlling the process. You know, are you ready to call your next witness? Can we move on? Can we get off this? Ruling on evidentiary claims. That, you know, that's the role of the chair. Also, the chair will probably take the first stab at drafting the award because he has to distribute it to the chairs for their input. And, you know, he or she just controls the process and rules on evidentiary claims. In terms of the decision, everybody's equal in the decision making. So if three of the three people are, you know, serving on the panel, you have to have a majority to have an award. You try to get everybody, but if you can't get everybody, at least two. And it doesn't have to be the chair. The chair could be in the minority in that situation. In terms of how you choose the chair, it varies. You know, it could be, again, it could be set forth in the arbitration agreement itself. I mean, that's the first place you need to go to look for an answer in terms of how the whole proceeding is going to operate it. And if it says, it designates how the chair is to be selected, then you have to follow the procedure set out in the arbitration agreement. If there's no procedure in the arbitration agreement, then, you know, then the institution may have its own rules. I've been recently was involved in an arbitration where the chair was selected by, either it could be selected by the institution itself, or it could be selected amongst the three arbitrators. So in that situation, you know, interestingly enough, one arbitrator said, don't worry about me, I don't want to be the chair. So it was between the two other arbitrators. And the two other arbitrators said, well, how do we want to decide this? Because both of them wanted to be chair. And what happened was very informal. We flipped a coin, and whoever got it, whoever was heads became the chair. So there are different ways you can choose a chair, but the main thing is follow what the procedure in the agreement. Absent that, follow the procedure in the institutional rules.
Okay. And so is the chair typically the one that swears the witnesses in?
Yes, yes. So, and swearing in of witnesses or giving them an oath is really, to me, I thought when I first started being involved in arbitrations, and maybe as litigators, maybe that the sort of oath has maybe evolved. At one point in time, you used to say, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? And, because witnesses come from so many various backgrounds, ethnicities, religions, cultures, it may be against somebody's culture, if you will, or religion to even swear. And maybe they're atheists, or, their God isn't the God, whatever. You don't want to be offensive with the swearing in of witnesses. So typically, instead of saying swear, we say affirm. Do you affirm that what you're about to say is the whole truth and nothing but the truth? And we leave out the so help you God. But also, as we've gone into COVID, and hearings have become virtual, people have started now adding things to the oaths, because you want to make sure that there's nobody else in the room with your witness, that they're not being coached, that they're not looking at documents that they shouldn't be looking at yet, or they're not following the procedures that have been set up for the conduct of the virtual hearing. So, people have suggested that in addition to giving the typical oath, that you also say stuff like, do you affirm that there's no one else in the room with you except those authorized people? Or that do you affirm that, no one unauthorized person can communicate with you? Because, people know that when they're on Zoom, they can, they're texting and doing things too. So, we want to make sure that we maintain the integrity of the process. So the oaths have been a little bit expanded.
Yeah, that's interesting. Having to factor in the technological considerations, texting while you're there. I think that's interesting to have to expand the purview of the oath. And quite frankly, I could see that happening in the litigation context as well. If a trial, having to kind of box them in and say, these are the rules that you must abide by, and thinking as expansively as possible, right?
Right.
So speaking of technology, I mean, there often could be failures that can happen, right? You can often have the Zoom goes out, somebody's camera's not working or whatever, or maybe even for that reason or other reasons, witnesses don't show. How does a panel, a chair or otherwise, deal with situations like that?
Well, the witness, the witness that fails to show, generally what we try to determine is why they failed to show. I mean, if they were sick or something like that, we have to really give people witness an opportunity to appear. And we generally will reschedule, like maybe there are more than 5 witnesses. If witness number 1 or 2 can't make it on that day, even though they were scheduled for some unknown reason, we would not say, well, we won't hear from that witness. What we will do is try to switch them so that they maybe appear at a different point in the proceeding. And especially if the proceeding is going over more than one day. Or even if a witness has an appointment, like they were scheduled to be on in the morning and it flowed through to the afternoon, and they've been sitting in the waiting room for 4 hours waiting to be called, and they have another appointment. We try to make accommodations. And I think that's critical, because we have to give the parties the ability to present their case. Because if we don't, that's one reason why your award can be vacated. Regarding technology, things happen. And if they happen, you have to make an adjustment. And, if somebody loses their connection or We've had situations where there have been storms and there have been outages and that kind of thing. You may just have to reschedule. But the hearing cannot go on, without the relevant parties. It cannot happen. And with respect to, interesting in arbitrations, at least for some of the arbitral rules, you can't enter a default judgment against a non-appearing respondent. So unlike a court case, if a party fails to appear, then you can just move for a default judgment. In arbitration, that doesn't work. What you have to do is continually give that person notice of the proceedings. You give them notice of the preliminary hearing. You give them notice of papers that are filed. You give them notice of the hearing. If they still don't show, you can proceed, but you have to decide the case on the merits. So, I have had arbitrations where only one party has appeared. And I had to listen to the evidence presented by that one party without the benefit of the respondent. And I can truly say that in at least one instances, I have ruled in the respondent's favor, even if they have not been there. So that's an interesting distinction between arbitrations and litigation.
Yeah, indeed, because it's not that it's rubber stamped, but it's a bit easier. The burden of proof is considerably lower
Right.
in litigation than it's like it is in arbitration.
Yes. So once you go through all the hearing matters, you want to close it out, closing arguments and that kind of stuff. And you may decide that there'll be post-hearing, that's the real estate person me coming out, post-hearing briefs, and you may have certain circumstances, I had to get an update of the calculation of damages because as time went on, the damages increased. So that we may get some kind of post hearing submissions. But
before you get to closing it out, are there motions that are presented? Do parties have the opportunity to raise and file motions during the proceedings?
Sure. Yeah, motions are I don't know if they always occur. No, they do not always occur, but it's not unusual. There are some motions that occur before before arbitration, some that occur during arbitration. The most typical one that I have, Bill, I'm not sure what your experience has been, but the most typical one I've gotten is a motion for summary judgment. So typical, like a trial at the end of the presentation of the claimant's case, the respondent may move for a motion for summary judgment. You heard all the evidence and they haven't presented their case, motion for summary judgment. And interestingly enough, in the FINRA environment, a motion for summary judgment will not be entertained pre-hearing. In other words, the party has to be given an opportunity to present its case at a hearing before you can even consider the motion for summary judgment. But yes, motions for summary judgments happen. And I have been in the situation where we have granted the motion for summary judgment because, it just probably if we had the ability to close it out pre-hearing under the rules, we would have, but we were not permitted. But there's a lot of movement toward dispositive motions pre-hearing because it sort of tailors the issue, streamlines that, it makes it more cost effective. People don't spend a lot of time presenting arguments that are not going anywhere. So you'll find now more that you will see more dispositive motions pre-hearing. Bill, is that your experience?
Yeah, I had the same experience. I mean, you see more dispositive motions or requests for dispositive motions. I've also had motions for sanctions that came up during hearings where based on conduct during the hearing. I'll talk about this a little bit as we get into the post-hearing discussion, but yeah, I mean, the parties are often looking to see if they can exclude certain things, if they can, get a motion, for like a directed verdict or not directed, but a summary judgment motion as a sanction. You're precluded from making the defense that you've made because of your activity. So yeah, it's one of several, but the majority of them, my experience is consistent with yours, Lisa. They're summary judgment.
Yeah.
quick question. What, in the context of an arbitration hearing, what happens if you have counsel who are not being compliant or are quote unquote unruly?
Well, you, in terms of unruliness, during the process and being disruptive and being combative, in that situation, you know, you try to rein it in as similar as a judge would. You know, everybody has their different styles and manner in which they conduct that. I think, you know, from my perspective, and Bill's probably is somewhat different. I'm always concerned about rolling up my sleeves and jumping in a battle with you. So, you know, I may let you run your course on, you know, being a little bit disruptive to each other. And then after you've finished, I can then admonish the parties and let them know that, you know, that is not the way this proceeding is going to be conducted. And that type of outburst and talking over and not talking to the arbitrator, whatever was going on, has to be checked. I don't want to be jumping in the fray with them because, you know, I think, and since we're on the Metropolitan Black Bar Association, CLE, I can say I don't want to be seen as the angry Black arbitrator. You know, that's not my style. I'm not an arguer. I'm not, you know, I don't roll up my sleeves. My negotiation style comes through very much in the way I arbitrate, you know, and that's basically, I try to take a lower key, but firm but low key stance. And when I say low key, that means I still will maintain control of the process, but I'm not going to roll up my sleeves and duke it out with you. I don't know, Bill, what's your policies on that?
Yeah, it's funny. I mean, we get to the same place. We just do it in sort of a different style. You know, I also, as a Black male arbitrator, you know, I know people are sort of looking at me and sort of, oh, is he able to control this, you know, these proceedings? This is surprisingly common. It happens in many arbitrations where the parties just sort of start going off on each other, personalizing things. I think it's what relates to what we were talking about earlier in terms of the lack of formality, or I shouldn't say lack of formality, the appearance of less formality. You go into a federal courthouse, you know how to act. You see that judge sitting up there in the front, you've got all the trappings of the power of the federal government. You control yourself. When you're sitting in a conference room, sometimes lawyers forget how to act. They just, like, you know, forget where they are, and they don't realize, you know, sort of how they're supposed to comport themselves. And they just sort of, you know, start, you know, ignoring you as arbitrator and directing all their arguments to one another and having little spats. So yeah, it's as an arbitrator, it's my job to make sure that that doesn't happen. I can't stop them from going at each other, you know, at any point, but I can rein it in as quickly as possible. I can make it very clear, and Lisa does the same thing. Make it very clear that's not appropriate, that will not be tolerated. My style is to interject in the middle of them, and to basically, you know, sometimes I'll just say counsel. I'll just, you know, do that over and over and over again, and then eventually I will, oh wow, he's speaking, and someone will be quiet. And then I can go and you know, launch into them about how inappropriate that is and how unacceptable it is. But I don't let them finish. I do stop it in my way, because, you know, I'm going to be judged as you know, how effective I am as an arbitrator by how well do I control the proceedings. And, you know, if this is happening over and over again, even the winning party is going to report back about me and say, yeah, you know, I'm happy with my decision, but he didn't really do a very good job of controlling the proceedings, even though that person was responsible for the problem, who created the problem by, you know, having these back and forths with their adversary. So they'll forget about that when they're criticizing you. So, you know, you always have to make sure that you are protecting your role, that you are assertive, not domineering, but assertive. And you make it very clear. I don't yell at people. I don't, like, you know, sort of join the fray, but I definitely want to make it clear who's the person that's running the proceedings. And, you know, everyone's going to understand that.
Bill and Lisa,
understand-
oh, go ahead. Go ahead,
I
Joe.
understand you have a little role play for us that you're going to give the audience an example of how this might go.
I was just going to say, sometimes it's more fun to see it actually played out instead of listening to it. Maybe we can get a little bit more from it. So we do have a role play that we have that we will quickly demonstrate what unruly counsel can look like, and how an arbitrator style may vary, and how one gets control of the room. And so, Bill, do you want to perhaps just give a little bit of a framework from where we're coming from?
Yeah, absolutely. So this is, and again, as I said, this is surprisingly common. You would be surprised how often this happens in arbitration proceedings. So this is a case where it's a garden variety contract dispute where the claimant is looking to get money on the contract, that they weren't paid for the services that they were rendering, and they're suing the company that signed the contract. They're also suing the owner of that company, claim, even though that owner is not a person who signed the agreement, because they're saying, well, it doesn't matter that the owner didn't sign. The owner is the one that's controlling everything. The owner's using the company as basically a shell. It's not a real company as far as we're concerned. It's really just the owner. And so we think the owner can be brought in as well. And that's also very common, that a party will try to extend it not just to the counterparty to the contract, but also to the owner, the principles of that contract, the principles of the company that signed the contract. So that's the basis of the dispute. In this instance, the opposing party, the respondent, is going to start out by making a request to have the arbitrator rule that the owner should not be part of the proceedings because the owner is not a signatory, and the owner has there's a corporation here, so the owner shouldn't be personally liable. And so we'll start with that and let the counsel, Lauren and I will play the counsel. Lauren's the counsel that's for the respondent who's going to be making this request of the arbitrator. Lisa is going to play the role of the arbitrator.
Madam Arbitrator, we would request a determination that Jane Doe, individually named respondent, be dismissed as a respondent. Since the corporate entity is the signatory to the contract, they are a named party to this, and everyone understands that a non-signatory cannot be included in arbitration.
Yeah, that's just ridiculous. I mean,
It's not ridiculous. That's how it is.
It's completely ridiculous. You're trying to get an upfront ruling without even having hearings. That you
don't need hearings. It's facts. She's a non-signatory to the contract.
We're sitting here at the beginning of the hearing. Let's just jump into presenting our witnesses. I've got a witness who's going to make my case on this.
She's a liar. She's a liar with an accent. You know that. You know very well that.
But no, you know very well.
Ladies and gentlemen, let me interject. Let me interject right here. First of all, we can disagree without being disagreeable. We're going to have to conduct this arbitration with mutual respect. I will not permit over talking. One party may not interrupt the other. Speak to the arbitrator. Direct your questions and concerns to me. Now, let's try this again. And if this happens too many times, I'm going to have to sanction the party that cannot abide by the rules and procedures of this hearing. So something like that.
Ready for our Academy Award?
I was going to say, and scene.
Right.
I'm like that. So
that's an example of how obviously Lisa, as an arbitrator, got control of us and used her style of not kind of bringing us in with a few. Did you hear me? Hello? Okay, I'm gonna let you go a little bit. Maybe they'll calm down. Okay, they're not calming down. Ladies and gentlemen, and then it's slowly asserting yourselves. And then I, as someone that's playing a claimant or a lawyer, was sitting there like, okay, well, I don't want to tick her off. At the end of the day, she is writing my decision, my award. So I've gotten what I set out. Let me now focus and listen. And I don't want to talk over her. So I think that to me was very effective.
And you know what's so important is being true to your own style, right? I mean, we all have different styles. Some people are much more, yelling, with people and like, they have very different styles. But you have to do what works for you. And you've been around, you know how to handle disputes. And you just stay true to that, and it'll be clear. So you don't have to be somebody that you're not. And I think that that is really important for every arbitrator to just be true to themselves throughout the entire process.
Agreed, agreed.
And so before we wrap up this section on evidentiary hearing, I just want to touch on 2 points. One, we talked about this panel, and we talked about their role generally and how they maintain order of the panel. You know, they keep control, they run all the evidence, and they write the awards ultimately. Do they have an opportunity to ask questions of the witness? And then what is something called an executive session? What is that? How do they go into that? What does that mean? Why does it happen? And yeah, so that's enough probably.
Sure, sure. So in an arbitration, you probably will get more questions than you will get if you have a trial, especially more questions than you would get if you have a jury trial, because I think the judge in some instances does not necessarily want to ask questions because it may influence the ultimate deciders of the fact who are the jury, who is the jury. So I would think that in a panel itself, I mean, you can be in your opening statement, and depending on the arbitrator style, I've seen arbitrators stop you right dead in your first sentence almost. And so you have to be adjustable, especially if you're a counsel in arbitration. Don't think that you're going to have the ability to just, go on ad infinitum and, just talk and talk and talk and talk. Most likely you're going to be stopped on many occasions. Now, when and where you're stopped and the panel asks questions, it depends again on the arbitrators. And if you have a panel of 3 arbitrators, you have 3 different styles. So I've been in arbitrations where one arbitrator was pouncing in right in, in the second sentence. And then there are other arbitrators who will wait and will make notes and will wait till you finish whatever you have presented, and then they will ask you the question. But you should expect a lot of questions from arbitrators. And I think one of the responses that an arbitrator does not want to hear is that, oh, I'll get to that. I'm gonna get to that. I'm gonna get to that down the road. So, arbitrator, you can wait. You probably need to develop a style where you can answer the arbitrator's question, but also get yourself back on track to where you are in your presentation, and not be sidetracked by the questions, because there will be more questions than you probably would expect in a trial. In terms of the executive sessions, I mean, that's when the panel decides that they want to discuss amongst themselves an issue that may have come up. And, it could be an evidentiary issue, a privilege issue, could be a summary judgment issue. Maybe we just want to discuss, how we feel about certain things. What is our take before we proceed? And we always have the right to go into executive session and discuss any aspect of the proceeding.
And that's a discussion just amongst the arbitrators, right?
Just among the arbitrators, right? And one thing before we go, in terms of closing the hearing, usually when you get to the end of the hearing, you want to ask the parties, especially the counsel, if there was any objections to the manner in which the hearing was conducted. And the reason you do that, it's almost like a best practice, because if they fail to raise an objection at the end of the hearing, then when your award is going for an enforcement or somebody trying to vacate it, it wipes out that issue of objecting to some aspect of the proceeding. If you have on record that everybody said, oh no, we were fine. The hearing was fine. Did you get a chance to raise everything that you wanted us to hear? Are you satisfied with the proceeding? That sort of shuts the door on a lot of the post-award processes to vacate your order.
Yeah, that's a really great tip for our practicing arbitrators and those that are aspiring to close it out that way, because that, as you said, precludes the motions that ultimately will come to vacate the award. Well, you look at the record. Speaking of the
Right.
record,
Right.
what kind of record do we have in arbitration? We talked about the differences between litigation and trial and arbitration. Typically, every trial is done on a record with court reporters present, and you could read back questions and answers and have a whole record to present. Do we have the same thing in an arbitration?
You can. It depends on what the parties want. A lot of times now we have these virtual hearings and, you hit a button and everything's recorded. But in terms of just proceedings in general in person, you often will have a transcriber. You may need simultaneous translation if somebody, is not speaking in the language of the other parties. I mean, I've been in situations where someone was speaking Portuguese and there needed to be a translation. So you may need a translator as well. But those things, generally, if you're working through an institution, they can be arranged through the institution. They can provide that kind of administrative assistance to get a transcriber or a simultaneous translation. Or I think FINRA requires a tape recording of the proceeding. So yes, you can expect a record if the parties want it, if the arbitral rules provide for it.
Okay, so that's helpful to know. So you just alluded to closing the hearing. So let's move on to closing the hearing. There are many considerations that are taken in when you're talking about closing a hearing. You can look at whether or not the hearing was done just on liability or whether the hearing was done overall. And so let's kick that off with talking about, Bill. Can you talk about whether or not hearings can be bifurcated? I know I recognize this decision would have been made early on, but in the event that trials or arbitrations are bifurcated, what happens when the hearing is closed? What is the step? What does the next step look like?
Right. So, okay. Typically, the issue for bifurcation is that the parties decide they want to try liability first. So why are we going to have all this presentation of damages, bring witnesses in to talk about damages if we don't even know that we're going to establish liability? So they often will make the argument that it's much more efficient to just try the issues of whether the respondent is liable, or if there's a counterclaim, whether the claimant is liable on the counterclaim, who's liable for what. And then once that's determined and there's a decision that's made on the liability, then they can come back with their witnesses to talk about damages. It's not uncommon. I mean, there are arguments both ways on that. Sometimes it is less efficient to sort of do that, to have a second round of the hearings to bring people back. You gain certain efficiencies just by doing it all at once, but there are parties that want to do it that way, and if that's how they choose to do it, then that's respected. Another way that cases can be bifurcated is on issues. There are some times where there are maybe 2 or 3 issues that the parties feel are key, even though there are 10 different claims. And no one's going to concede on the other 7 claims, but they think that there are 3 that really sort of put everything in clearer relief for them as to what the contours going forward will be. So if they can resolve these 3 issues, they'll probably be able to sit down and work out the rest of it. They'll be able to sit down and come up with a settlement that makes sense. But these 3 things have to be resolved first. So you'll work this out before the start of the hearings, where they'll make it very clear, we're deferring issues 4 through 10, and we're only addressing issues 1 through 3. And that everyone understands that the witnesses are only on issues 1 through 3, and whatever decision that I make would be limited to issues 1 through 3. So if that is something that the parties have wanted, either on damages versus liability, or on some issue versus some other issue, at the conclusion of the hearing, we'll treat it as if, it's sort of that's the first part. Then we'll make sure that the parties would have opportunities if they want to make. I know this is something we're supposed to talk about in terms of post-hearing briefs. Sometimes the parties want to have an opportunity at the close to. They may have made a closing argument, or they may have deferred the closing argument and want to do it in writing because they think that it'll be more impactful to have, their arguments, summarizing all of the testimony, summarizing their arguments in writing for you, a month after the hearing. You give the parties a reasonable amount of time to do that. It's usually something like, 30 days. Sometimes the parties want faster turnarounds. Sometimes they want to do it in 2 weeks, but they'll agree on the amount of time, and usually you're equal. So if one party wants 2 weeks, the other party gets 2 weeks to respond. Sometimes you just do it in simultaneous briefs and leave it at that. So instead of one side going, the other side responding, and the other side replying, you might have both sides submitting a brief, and then maybe both sides responding to the brief simultaneously. So there are lots of ways to do it. I do that working with the parties on what they both want. I rarely impose that on the parties, because that's just not, they're trying to find the best way to present the evidence. I'm not going to dictate to them how they best can present the evidence. And so if it's bifurcated, then we'll have a decision on that bifurcated part. And then we will then start the process again for the second part. So we'll have a preliminary hearing, and we'll go through the issues and the timing, make sure that everybody has all of the documents and depositions if necessary. And we'll set the timing for the second round of hearings. A lot of times what happens though is between those hearings, the parties will resolve it, or at least they'll sit down and try to resolve it. Sometimes they don't. And I have one case that was bifurcated. They were supposed to go, they left the hearing on after the conclusion of the first round. And I gave my decision. And then nothing happened. We sort of checked in with them periodically. Oh yeah, we're working on it. We're trying to resolve it. We're close. And years went by, and they, 3 years later, they still hadn't resolved it. And then one side had the nerve to then try to dismiss the original decision, saying that it was stale because had been more than a year, and they cited to a New York provision of the CPLR that says you have to confirm an award within a year. So even though the award was still open because we hadn't finished the proceedings, but that's another story. That case is actually still pending, and I'm curious to see how it plays out.
I was just going to ask Oh, go ahead.
Oh, let me just ask Bill a question. Bill, from a arbitration manager perspective, have you ever had an arbitration that had so many issues that you wanted to bifurcate it and compartmentalize certain of the claims, so that instead of a party or claimant presenting his claims 1 through 10 all at once, that you decided that to better manage the case, that you wanted to have certain claims 1 through 2 heard, and both parties present on those claims before you move to some other aspects of the claims?
I've never said that to the parties directly, like I want you to do this because I think it's the best way to go. I might feel that way, but I haven't said that. And so, if I think that the parties might be better served by dealing with certain issues first, I might suggest it, have the parties discuss the issue of whether you want to bifurcate. I know that, you've spent a lot of time talking about issue X. Do the parties feel that you want to resolve issue X and then come back to the other things? So I'll put it out there without, sort of suggesting that one way or the other, just as we're talking about how to structure the case. And then we'll see how the parties want to go. But I'll take my direction from the parties. I'll put it out there. And if nobody jumps at that opportunity, I'll just pull it back to myself and move on.
You actually asked what I was curious about too, Lisa, as whether or not there were issues that the arbitrators feel like, what I want to actually bifurcate these issues. But yeah, I think that was a great question. But also I'm curious, that issue is something that is often seen to parallel it to trials. That's often sometimes seen, particularly when you have co-defendants and they have these cross claims amongst themselves. They're like, let's figure out liability first, and then we'll start pointing the fingers at each other. So perhaps that's also something similar seen with respondents. If there's multiple respondents, let's fight, against claimants first, and then we'll kind of look at each other separately. Post-hearing briefs, you touched on that a little bit, Bill. Is that something that's required in every case, or do you treat that the same way you treat pre-hearing briefs, and that it's optional?
It's slightly different. I won't force parties to do post-hearing briefs, particularly if they've had the opportunity to do a closing, if we have, a court reporter who's taken down everything, then, sometimes parties feel that that's duplicative. Sometimes they feel that they choose between doing a formal closing and doing a brief. So some want to do both. I've never had one that wanted to do neither, but sometimes they want either or. So I won't force them to do it. If it's a particularly complicated case, I might suggest that they consider post-hearing briefs to just really kind of make concrete the arguments and the direction, that it's a tool. It's definitely a tool for me as I go through the deliberation process, trying to decide how I want to, what decision I want to reach. It's very helpful to have the arguments laid out. It's a lot more work for me if they don't do it that way, because I have to basically pull it all out of the evidentiary record. But I won't make them do it. And again, particularly if they've done a closing, if they've chosen the closing and believe that that's it, that should be the final word, I won't require it. I will strongly suggest that if one side, this is a question relating back to the question for pre-hearing submissions, if one side wants it, both sides really should do it. That's not, I don't want to have a lopsided record where I've got this, 50-page closing brief from the claimant and then nothing from the respondent. And then the respondent loses the case and, it looks like there was some disparity. So I really will push them for equality, and suggest that, you really, if one side's doing it, the other side should do it. And they usually take you, I haven't had a case where the other side has not chosen to do that when the other side wanted to do it, even if they initially didn't want to do it. So they usually realize they need it for parity.
Yeah. And in terms of, I guess, speaking of post-hearing submissions, how do you treat motions for sanctions? Is that something that you expect to be made at the conclusion of a hearing? First of all, are they available? Sanctions available? I think Lisa alluded to the fact that she could issue sanctions as an arbitrator. So can another side request sanctions of the other side? And is that typically a request that's made at the end of the hearing, sometime in the middle, or what's your style and preference on that?
It's often, first, arbitrators definitely have the authority to issue sanctions, and it's a pretty broad authority, subject to perhaps an arbitration clause that would restrict the arbitrator's ability to do that, but that's pretty uncommon. And so in the absence of that, there's broad authority for arbitrators to do it. I had a case, I think this past spring, where actually last fall, where there was an issue during the hearings about documents, and what the testimony was coming in from a witness. Oh yeah, we had this schedule, we had these audit reports and financial reports for all these years, and yeah, I'm aware of, we had them from 2005 to 2019, and the other side objected and said, well, you never gave those to us. We asked for those over and over and over again, and you never responded. And you said, in fact, you didn't have those documents. And now we're hearing that this witness is saying that he has these documents. What's going on here? And so we had to go through this whole process. Documents were produced during the hearing. And then the other side made a motion for sanctions. And the sanction they asked for was the dismissal of the claim for the improper refusal to provide information that they knew was available, and in bad faith had chosen not to provide. And the other side said, no, it wasn't bad faith. It was a misunderstanding about the information. We weren't aware. We didn't know these documents existed, blah, blah, blah. So we had a motion on sanctions. It just happened in that case that we were not able to finish the hearings because we had, a lot of times you want to have, I think ideally you want to have hearings that just go consecutively. If it's going to take 10 days, let's just take 10 days, knock it out. So we don't have to sort of like revisit the wheel, come back to these issues, try to remember the testimony 2 months later when everybody can get back. But sometimes that's just not possible. And no one has the 2 weeks available in their schedule. And they request to have, sort of staggered hearings. So it's 3 days here, 2 days here, 3 days here. So we were at the end of the 3-day period that they had agreed to. We needed to have like at least 2 more days of hearings. And they asked to delay the next 2 days of hearings so they could brief this issue of sanctions and get a decision on that. And they were hoping that would be the end of the case and there wouldn't be a need for those remaining 2 days of hearings. Of course, that didn't happen. I thought the sanction of dismissing the claim was far too extreme given the circumstances. And so In that case, I actually did not award sanctions at all because I didn't think that they were appropriate given what the reasons were for the non-production. And then we continued. But so you could have that happen at the end of the hearings, and you can have it happen at some point during the hearings. But if you're going to have the request for some type of a dismissal of a claim, striking of the answer, you probably will have to give that decision before you proceed with the remainder of the proceedings.
So Bill, in that case, were the financial statements ultimately produced?
They were produced, yeah.
Okay.
And if you kind of alluded to maybe the answer to the question I was wondering, does the issue that is the basis for the motion to sanction need to be preserved in any way, or have been raised at some point prior to the sanction motion, or can someone just spring it upon you? I didn't like the way you questioned that witness on day 1 of the hearing, didn't say anything then, but I'm going to bring it up on day 7.
Yeah, I mean, they're usually pretty good about raising the objections like right on the spot. I mean, one of the things about, when you serve as an arbitrator, either as the chair where you have, the 2 people with you, or by yourself as a sole arbitrator, you're dealing with objection after objection after objection. I mean, it's a litany of objections. It's actually one of the challenging things that when you first do it, it's a little frightening to know that you're basically on the firing line for day after day after day. You're responding to hundreds and hundreds of objections for little things like compound question, leading question, asked and answered, to very big things like relevance, prejudice, and things like that. And you have to sort of, have your common sense, which we talked about earlier, as your guide. So yeah, they're usually not shy about making objections at the time, particularly when something major happens. I've never had a situation where something happened on day 1 and on day 8 for the first time, the counsel raised it and said, "Oh yeah, well, this is sanctionable conduct." My response to that would be, "Well, you should have raised that on day 1. We're a little past that right now, so let's move on. You didn't take it very seriously, obviously, if you waited 8 days to raise the issue. You didn't think it was very important."
They've been sitting at home mulling, what can I use? What can I pull up? And it's like, all right, that one. So that's interesting. So when this all comes to an end, is the date that this hearing ends, and Lisa spoke a bit about the scheduling in the beginning, and I think you did as well, is the anticipated date for the closing, is that contemplated in the beginning when you're doing your scheduling? And then how firm is that closing date? And does that include also the filing of the post-hearing briefs?
So the closing date being the closing date of the record?
Yes.
Yeah, so the closing date is not really set. The closing date depends on sort of whether there's a need. So the most common situation is at the end of the hearing, the parties have decided they want to have an opportunity to submit post-hearing briefs. So in that instance, we'll create a schedule on how that'll happen. That might stretch it out for as much as 2 months from the end of the hearing, because, I have vacation coming up. And then the other side says, "Oh, I have vacation coming up." And before you know it, they've pushed it off. And I give them as much time as they need, as long as it's, by consent. It's not one side saying I need 2 months and the other side saying I want it in 2 days. They usually are, for the most part, on the same page. So that is something that will be required before we can close the record. It's possible, not usual, but it does happen, that after there's a submission, there is still a question that I want to have resolved on a hearing or on further briefing. I actually had a case not too long ago, a few months ago, where the parties had, this was not live hearings, this was briefing. And one of the issues was actually an issue about whether a company could claim an individual, sort of related to the role play, whether an individual could be sued because there was a corporation, and there was a question of whether that corporation was a valid corporation or not. And so the parties agreed on briefing, they knew what the issues were, and all of a sudden on the reply, the last go around for the moving party, that's when they chose to introduce all this new evidence about, "Oh, well, I know we had a corporation that was dissolved, but we reinstated it. We reinstated it 2 weeks ago. Under local law, that reinstatement means the company is basically always considered to have been valid. So it's retroactive to the original date of the filing." And they produced this for the first time citing, the statutes from, regarding corporations in the reply brief. So in that instance, even though I had initially intended that to be the last word, I gave the other side an opportunity to submit a surreply, just because I thought that's not fair that they got blindsided with this at the last instance. We're going to close the hearings and I'm never going to hear their side of what the argument is about whether this dissolution was retroactive or the reinstatement was retroactive. I want them to at least be on the record telling me what they think the law is. I'm going to have to look up the law. I'm going to have to make a decision, but I want to hear what they think the law is. So, and not have them say, I never got a chance to present it. So that's an instance where I thought I knew when the record might close, but then I had to extend it out because of the circumstances. So when I'm satisfied that I have all the information that I would need in order to prepare my decision, which is the award in an arbitration, that's when I will close the record. And usually the case administrator will write to me and say, can we close the record as of this date? And I'll write back and say, assuming that I believe I have everything I need, yes, we can close the record, or no, let's have another telephonic hearing on this date, or here's what I need to close. Sometimes what I need is, if there's an attorney's fees claim, I might want to have those fees if they've never been submitted. We usually would have worked that out, a schedule for that. But if there's something that comes in late, one party wants to submit a last bill, I'll give them that opportunity to do that. If I don't want to close the record and then not be able to consider that part.
Now, Bill, let me ask you, have you ever closed the record and had to reopen it?
No, I've never had to do that.
Okay.
So you want to be very careful. When closing the record is a big deal. When you close that record, if you open it again, you're definitely going to get some objection from the other side, claiming that you had no authority to do that. They weren't given an opportunity. It just creates a lot of opportunity for mischief for the parties. And if one party knows they're on the short end of the stick, they're looking for those opportunities for mischief. So yeah, I want to be very clear when I close the record that I'm not going to need anything else.
I will say that's very benevolent of you to permit surreplies, because there's many judges that will say, you raised a new issue on reply, I'm not listening to it. You should have raised it in your moving paper. You're trying to be slick. So, that issue, you're going to hear it and entertain it. The right thing is to let you get the full picture of at least giving them the opportunity for response. So that's, I appreciate that as a practitioner, from a practitioner standpoint, that you would do that.
Benevolence is part of it, and curiosity was part of it. I just want to see what the other side was going to say. The other part of it too, though, is and we'll talk about this. I think Lisa's schedule will talk about this later on, sort of grounds for overturning the award. But one of the things that that is first in the arbitrator's mind, the main reason for or certainly one of the central reasons for overturning an award is that a party claims it didn't get an opportunity to present its evidence. So I really don't want to cut a party off from presenting crucial evidence. It's one thing if they want another opportunity to ask a question and they've had plenty of opportunities and I can cut that off. It's another time if they say, yeah, but we had a whole defense to this entire line of argument and we never got to present it because you didn't allow it. I probably would be able to have my award sustained. I could probably say, well, you were cut off, you just didn't get the opportunity. Yeah, I disallowed your reply because it presented all this new evidence, but it opens the door to further process. And I really would like my decision to be the final decision in the case. I don't want them to run across the street to the courthouse and try to vacate my award or ask. They're going to do it if they're going to do it, but if there's a way that I can stop that, I would prefer to try to stop it.
Okay. So moving on. So now you've gotten all your submissions. You think you're ready to make this decision, as you said, and we've already discussed in the arbitration world, the decision is called the award. Talk to us about what types of awards are there, and is there a deadline for you as an arbitrator to submit this award?
So there's different types of awards. Some of them are stipulated in the arbitration clause, which a well-drafted arbitration clause, I don't know if this was covered in the first part of the series, but I mean, you can really clarify a lot of issues if you take the time as a party to think through the issues of an arbitration. But one of the issues can be sort of the form of the award. So an award in an arbitration can be a simple award. which literally can just say award in favor of the claimant in the amount of X, signed arbitrator. That's it. That can be your award. It could be no more than that. You know, you don't have to worry about interest. You can if you want, but it could literally be that simple. And I remember that, you know, when I started as an arbitrator, there were a lot of arbitrators who believed that that was the way to go, because that award, you can't do anything with that award in terms of attacking it. It is unassailable, right? I was asked to make a decision. I made my decision. That's it. You can't say that I was wrong on point X or I didn't understand point Y. It is what it is. I actually, from the beginning, didn't believe in that, though. I have always felt that in a decision in a litigation, an award in an arbitration is really an opportunity for you. The winner doesn't care. The winner just looks to the end and wants to see that they won and what they're getting, and they're done. It's an opportunity for the loser to understand that the process was fair, that the arbitrator was not asleep or dumb or, you know, didn't get the arguments, that I got the arguments. I heard you very well, and here's why you didn't win. And so I think it's really important for you to believe in my abilities as an arbitrator, and not run off to court and try to, you know, do what you can to undo it. I think it's really important for the process too. I mean, you know, I do most of my arbitration for the American Arbitration Association. I'm fortunate enough to be part of their panel. They're the organizer, they're the sponsor of the arbitration. They're the entity that was probably chosen in the arbitration clause. I don't want the parties to feel that the process is bankrupt. Why was I subjected to a American Arbitration Association arbitration when I could have gone to court? I want them to realize, no, you got a fair hearing. I want the client, when the client reads their lawyer sends them the decision, the client to understand why they lost. I think that's really important. So that is a reasoned award where you set forth what the claims are, why you reached the decision that you reached, how you interpreted the evidence. And that can be, there are two ways that you can do that. You can do it with findings of fact and conclusions of law, which is very formulaic, where you lay it out point by point by point, and then you address each point with your conclusions. And it's a much more structured document. Sometimes you can have it proposed by the parties. They can draft they can prepare drafts for you of their findings of fact and conclusions of law, and you can take from it in your final, as happens in a court proceeding, where you know, there are proposed orders that are submitted to the judge, and the judge can pick and choose what he or she wants to use as part of the final award. And that happens every now and then. It's a more expensive process. The more time that I have to put into the award, since I'm charging by the hour, and the parties are paying for me by the hour, the more expensive that process is. So often they don't ask for that out of cost reasons, but a reasoned award, when they get the opportunity to have a reasoned award, they usually jump at it because they want to know, what were you thinking? Why did we get where we got? And for the reasoned award, I often will just structure it in terms of, here were the claims, here was the key evidence that was presented, and here's where I came out in terms of my determination of the evidence. Sometimes in more straightforward, simpler cases, it might just be the burden of proof, right? It might be that, you know, there's nothing more to my decision than the claimant didn't meet its burden of proof of establishing that there was a breach. And it's actually really heartening sometimes to have that. Like, I struggle, like, you know, how am I going to decide this case? And it's not unusual for you to not know how you're going to decide a case at the close of the hearing, because you have to go back and look at everything. You've got to review all that testimony, review the transcript, look at the exhibits, match the exhibits to the testimony. And as you go through that process, then it becomes clearer to you, like, oh, okay, this is what happened here. This is the way this decision should go. But a lot of times, you know, it happens that there's no clear answer based on that. And then you fall back on, well, if there's no clear answer to me and I can go either way, I guess the claimant didn't meet his burden of proof, or meet its burden of proof. And that can be a factor of, you know, how you make a decision. So your question in terms of like the types of awards, those are the types of awards. Very simple, some measure of reason to, you know, from a very detailed reason award to 2 or 3 pages of reasoning, the key points in my reasoning. to an extremely detailed findings of fact and conclusions of law where everything is laid out.
And before we move off of arbitration awards, just two more things. Do you have a deadline by which you need to submit your arbitration award? And then the second part of that is, after you're done, you've submitted everything timely, do you destroy your documents? Is there an obligation to do any document destruction, or is that up to the arbitrator? Right, so you do, your first question, you do have a deadline. It's usually set by the rules of the organization. So the American Arbitration, so for a commercial litigation, commercial arbitration, you have 30 days from the close of the record to submit your award. And you have to factor into that time that you have to prepare a draft of the award. You have to submit the award to the American Arbitration Association, to the case administrator. They have to format it. They have to make sure that, you know, there's no problems with it. Usually from an administrative perspective, they're not second guessing the substance of your award, but there's a lot of administrative logistical issues that go along, and that can take a bit of time. So you cannot wait until the 29th day, send it over to the AAA and say, okay, here's my award, you know, prepare it for my signature and I'll sign it tomorrow. If you do that, you probably won't get a lot of requests from them to be an arbitrator on other matters, because that puts them in a real jam, and they don't like that. So you have to be respectful and give them at least a week in order to prepare the final award that's ready for your signature. So I feel I've got about 3 weeks to have a draft award that's ready for them. And I'm sorry, your second question was? The question is, after you've prepared that award, document destruction, is that an obligation? Document destruction. So there's no set obligation for when I destroy my documents. There is an opportunity for the parties, after my award is issued, to request a modification of the award. The modification rules, this goes back to one of the central issues of being an arbitrator. So arbitrators have tremendous power, tremendous authority and discretion, far more discretion than a judge has, because a judge for that particular case is much more limited to the rules of evidence, the rules of court, the rules of procedure. And when the judge deviates from that, there's an appeal, and the judge will, you know, be held to account for that. Arbitration is much more flexible for the arbitrator on that. I have a lot more room to make decisions on all of that. So from that perspective, you know, that's a big plus for the arbitration, for the role of the arbitrator, as opposed to a judge who's worried about the potential of being overturned. But one of the issues for an arbitrator also is that tremendous discretion and power ends the moment that I sign that award. My role is done. I can't go back and revisit issues. I can't say, oh yeah, you know, I thought about issue 1 and you're right, I really shouldn't have given it to claimant, I should have given it to respondent. That's not my role at that point. I'm done. That award is done. And the only thing that I can change are ministerial, administrative things. If I wrote 200,000 when I should have written 300,000 and it was just a mistake. If I wrote claimant and I should have written respondent and it was a mistake, those kinds of things that I can correct. There's a time that's set forth in the rules for me to do that. The parties will have a time to make the request for a modification. They'll both have an opportunity to be heard on whether a modification is appropriate, and then I'll have a time to make the modification. And then, so once the modification period is done, really my obligation to preserve documents ends. And at that point, there may be a future of the case. They may go to court. They may try to vacate my order or my decision, my award. But if that happens, that has nothing really to do with me. My reputation, maybe to a certain extent, depending on the grounds for vacating it. But no one will come back to me and say, Arbitrator Crosby, can you look at this issue again and, you know, correct that? That's not going to happen. I'm done. Some other arbitrator might get to do that, but not me. So I'm free to destroy the documents at that point.
Okay. So I'm going to jump in here and provide the CLE code. I'm going to say it a couple of times, so you're not going to see it on the screen. The CLE code that you'll need to put into the questionnaire that the Metropolitan Black Bar is going to send you is dispute resolution. The CLE code is dispute resolution. And for those who have asked questions, we are trying to stay on time so that we can address your questions in the last 10 minutes. Thank you. Dispute resolution is the code.
And thank you, Jill. And Bill, you teed us up right into the next section, talking about vacator of arbitration awards, kind of bringing this home for a landing. As Jill indicated, we have questions that have been asked of you guys, so we want to make sure we allot some time to get to them. So Lisa, I'm not gonna rush you, but in as succinct words as we can, maybe 5 to 10 minutes or so, let's talk about what it means to vacate an award. How do parties do it? What are the grounds under which parties can seek vacator of awards? And maybe on the tail end of that as well, we can also speak a little bit quickly about arbitrator malpractice insurance and what that is, and do you need it, and do you have it, and is it easy to get?
Sure. So the Federal Arbitration Act is an act that deals with the validity, the irrevocability, and the enforceability of arbitration agreements. It basically says that if the parties to a contract have agreed to binding compulsory arbitration, that agreement will be enforced. And that once an award has been issued, that arbitration award can be taken and confirmed in the court and reduced to a judgment that is then enforceable like any other judgment issued by a court. And so, that whole, the FAA was enacted under the Commerce Clause, as under the U.S. Constitution, where the Congress has broad authority to regulate interstate commerce. And so that's how it was enacted. The FAA then has been used and to enforce and make irrevocable a lot of arbitration awards. Now, as an arbitrator, one of your main things is you do not want your award really overturned. That is one of the things that you want to get right. And so there are grounds to vacate an award. So you have to be careful as you conduct an arbitration that you do not give a party grounds to vacate. And the Federal Arbitration Act sets forth those grounds. And I think Article 75 of the civil rules, New York civil rules, have the same concept of the Federal Arbitration Act in it. And it to some extent, it gives you a little bit more explanation of what some of the grounds to vacate are. So one of the first grounds to vacate is that if the award was obtained by fraud, duress, or corruption. And I'm gonna run through these fast because I've been asked to. And the other thing is that if you were not, as an arbitrator, independent and impartial. So before you even take on the assignment of an arbitrator, you are polled in terms of whether you have any connections with the parties, any connections with the counsel, any subject matter connections. If you were involved in similar type of disputes, then they may consider you to be not independent and impartial. And it's important that you constantly update those disclosures. So there may be something happens that in the middle of the arbitration, we hope not, because you don't want to be substituted out at that point. But if there's some disclosure you have to make, there's a continuing obligation to make those disclosures so you make sure that your award is independent and impartial. Another area, and we talked about this before, is where you can overturn an award because an arbitrator refused to postpone a hearing. After being given sufficient cause. So a party was sick, or a witness couldn't appear because of death in the family, whatever it is. If there's sufficient cause shown, you have to grant it in postponement. If you don't, your award is subject to be vacated. Another grounds is if you refuse to hear evidence that was material and pertinent to the controversy, or you let one party present his claim and didn't let somebody else, the respondent, present their rebuttal of that claim. That would be a matter where your award may be vacated. And any other kind of misbehavior that may have prejudiced the rights of any party. Now, New York, the Article 75 sets forth some of those type of things that might prejudice the rights of a party. And one is if you have a valid agreement to arbitrate was never made. So in that instance, when you either you have an agreement beforehand, it's in your other contract, and when you start looking at arbitration agreements within the body of a bigger agreement, they sort of look at those two agreements as separate. They'll determine whether the arbitration agreement is valid before they even determine whether or not they can stand apart, the breach of contract and the contract itself, but the agreement to arbitrate must be made. If there wasn't an agreement to arbitrate, that could be a reason to set it aside. So a lot of the institutions have the parties execute agreements to arbitrate if they don't have a pre-existing agreement to arbitrate. It also could be that you didn't comply with the terms of the arbitration agreement. The arbitration agreement said, and some are in very expedited tight frames. If they say, that the decision has to be rendered 30 days after the filing of the complaint or the claim, if you would, or the demand. If it's not entered in that period of time, you may have a reason for your award to be vacated. If it says, we're not permitting any motions, no dispositive motions, and you permitted dispositive motions, there may be a reason for you to have your award vacated. So you have to look at that. If you award interest and it says no interest to be awarded, you award punitives and it says no punitives. If you award attorney fees to the prevailing party and the agreement says no attorney's fees, everybody pays their own. Those are the kind of things that will get you your award overturned. And also, if there is a statute of limitations issue, if for some reason the claim was not brought within, the demand was not brought within the statute of limitations, that could be a basis. You also look at whether the arbitrator exceeded his authority, or there was some arbitrator misconduct. There are a lot of examples of arbitrator misconduct. It could be, for failing to be a neutral justice, or making an award completely against public policy, or you are biased, or you didn't decide all the matters, or there was a procedure in which the hearing was agreed to be conducted and you deviated from that. I mean, there are a lot of ways to get your award overturned. So, I can go on and give you more examples, but, that's the basic of it. Now, in terms of arbitration and malpractice insurance.
Before you move on to that, I do want you to talk about that for 2 minutes, but just to kind of put a pin on that vacator discussion, is there a time limit, a statutory time limit by which people have to seek vacator of the arbitration award?
Yes. So first of all, if you want to enforce the judgment, you have to take it to a court within a year.
1 year.
1 year to enforce it. And then if you have objections to the arbitration award, I believe it's 90 days? I think it's 90 days for you to set forth any objections.
Okay.
3 months if you're going to challenge your award and you're the non-prevailing party.
Okay, now please close us out with a brief discussion about arbitration, arbitrator malpractice.
So the thing with arbitration malpractice insurance is that you really need to read your policy. And in the materials, we pulled out a policy and we determined, well, it was a good exercise for me as well, because I've always thought that I was covered. My actions were covered, but in this particular situation, it made me pull my policy and see how the term legal services was defined. And in my particular policy, it says that legal services includes services as arbitrator, mediator, neutral, notary, So all those type of things are covered. So you should probably look at your policy. Hopefully everybody has some semblance of a malpractice policy. Even, we're a small firm and we carry 2 million, 1 million. And even when I was a solo, I carried probably 1 million, 1 million. So it's important to bite the bullet and get that insurance, so that you have the coverage that you need.
Okay. Well, there's a lot more that we really could talk about. And I'm seeing from the chat, people really have found this very informative, very helpful, some veterans, some newbies, and everything in between. There are several questions that have been asked of the panelists, and I'd like to try our best to try to get to as many of them as we can. We may not be able to touch them all. But I will just jump right in and see if we can get started. So the first question, and feel free, audience, now that we finished the formal portion of the panel, if there's some questions that you have, please feel free to either write them in the chat or the Q&A, and as I said, we'll try to get to them. So the first question is, do you take notes, and this is for both Bill and Lisa, do you take notes from every witness and every counsel argument during an arbitration hearing? So how do you deal with taking your own notes? And I know, Jill, you might want to comment about your own specific note-taking practice that you have.
I'm an extensive taker, but I'll leave it to our panelists to go deeper. Go ahead.
I'll start. I mean, yeah, you absolutely do need to take notes, right? So, and that's regardless. I mean, there are some cases where there's no court reporter. If it's a small matter and the parties don't want to spend the money on a court reporter, they're just going to show up in front of you and they're going to argue their case. And if you haven't been taking notes, you're going to have no idea how to make a decision at the end of the case. You're not going to remember even who showed up in front of you. So you need to have very detailed notes, very clear understanding of exactly how things are presented, which exhibits were presented by what witness, matching everything up perfectly. And even when you have a record, a transcript, which is a nice help, it's great to have, a complete record of everything that happened. I still take extensive notes because I will be able to note where I had a question, where I found particular exhibit to be very important, or a particular statement that a witness made to be very important. And when I'm looking back at the end of the process, trying to read the record, I can look at my notes and it can help me focus on where in the record I want to go, to find a particular thing that sort of struck me as central. So yeah, you have to take excellent notes. How you do it is up to you. I mean, a lot of us, I'll do them in shorthand, or I say longhand. I'll write them out. Sometimes I'll use like my computer and I'll type them out. I used to have an iPad that I used back in the day to take the notes, but however you choose to do it, as long as you're keeping a clear record, that's essential.
And Lisa, how about you? Do you take notes?
Oh, absolutely. And actually, there are CLE courses just on taking notes for arbitration because it's that important. But yeah, I take mine so far. I've used longhand. I'm somewhat old school in note taking.
Wow, so classes on our note taking, so it really can get very particular there. So good to know. Another question, do you conduct your own research to supplement what the attorneys have submitted throughout the duration of a hearing? And I guess this is in anticipation, perhaps for writing your award or just in overseeing your hearing.
Yeah, yes, I do. Depending on sort of how clear the record is based on the parties. So, one of the things about when Lisa was talking about sort of the grounds for vacating an award, there are many grounds for vacating an award, but it's not easy to vacate an award. I mean, it has to be there's a default basically that's sort of built into the system that arbitration awards will be allowed to stand without extensive court review, except on certain circumstances limited, that are enumerated in the Arbitration Act, Federal Arbitration Act, and the way the states have interpreted that. So you want to be right? I want to be very clear on, that I've gone through. I want to come up with the right decision, and if I feel I need to supplement the research that's been provided by the parties to do that, I will. It's not my preference, but I will do it.
And you, Lisa?
I pretty much the same. You know, I do rely heavily on what's presented to me, at least as the start and the basis. I will look up and read some of the cases that have been cited. And again, a lot of these issues, we have our own subject matter expertise. You know, we know the law. So it becomes easier in those situations where you know the law. So you may rely on what they have presented to you. You may rely on your own expertise. You may rely on reading some of the cases, but it really will vary case by case.
Have you ever had times where you're experts in this area and you know the law, and for some reason the claimant or respondent, they just missed it? And did you ever go back to them and say, you know what, why don't you look at this particular issue in your post-hearing brief or this particular case and tell me, you know, how it applies to what you're talking about here? So basically pointing them to the information that you know exists, but they didn't provide for you.
I have not done that. Bill, I don't know if you have or not. I have not done that.
Yeah, I haven't done that. I've been surprised that I've seen counsel cite the wrong statute, not cite the statute that was right next to it. That was the one that actually supported their argument, and they didn't cite it at all. So yeah, I've had things like that, but I've never had a situation where I've gone back and said, you should, tell me about this. And we're hired because we have general expertise in the particular area. But, if you have a contract dispute, we're not masters of all things contract. We don't know all of the law. And you might even have law that's presented from a different state or different jurisdiction. It might be a New York arbitration clause, but it's decided under Illinois law. So, I may not know exactly. I need the parties to tell me what's Illinois law on this particular point. So, but yeah, like Lisa, I haven't had the situation where I've had to do that.
Okay. There's been one other chat. I'll just say it out loud in case anybody else is curious. Somebody inquired as to who sells malpractice policies, and the answer was put into the chat. There are New York State Bar Association has insurance providers as a member benefit. Also, USI Affinity is one insurance provider, and the ABA and the New York City Bar also is believed to have relationships for their members. So there are a few options out there. We have time for probably one more question. Jill, did you want to pose a question for the chat?
Well, so not necessarily a question, or maybe it's a comment that the panelists can speak to, because Lisa talked about earlier the role of the chair and that the chair makes decisions, and she also talked about executive session. And often when I'm doing arbitrations, most of the arbitrations that I've been assigned lately have been single arbitrator. So obviously there's nobody else to confer with. However, when it's a panel, I always find it a best practice, and I'd like Lisa and Bill to comment on this, to talk to my fellow arbitrators about how we're going to conduct ourselves during, particularly if I'm the chair, I'm going to have a conversation with my fellow panelists and kind of set some expectations in a very sort of polite and professional way, so that we don't have what Lisa described sometimes like runaway arbitrators asking all kinds of questions and not allowing the parties to do their work, the parties' counsel to do their work. But also, I think one of the trainings for FINRA I did early on, they suggest that the chair asks permission of the fellow arbitrators to make evidentiary rulings without conferring with them. during the hearing, and FINRA actually has certain rules that say that only the chair makes certain decisions. But I just wanted Bill and Lisa to comment on that, how you deal when you're obviously not a solo and you have fellow panelists. Talk about the relationship with the other arbitrators, and maybe an example of sometimes when it goes well and sometimes when it doesn't go so well.
Well, I mean, Jill, your point is exactly right. You want to make sure you've had that discussion with your fellow panelists. When I'm chair, I want to make it clear that I'm the person who's going to be responding to, I'll do it in a very democratic way. I mean, I'm not dictatorial. I suggest, perhaps, for efficiency's sake, I'll be the person that deals with the whatever the evidentiary objection is. And unless I'll make a determination, if I think it's a question that's a really substantive issue that we should all weigh in, I'll convene an executive session and we'll discuss it. But, for the garden variety issue, I'll be the person that makes a decision. And even if I'm wrong, you'll respect that. I mean, that's an important part. I may be wrong, right? I may overrule an objection that should be sustained. I may sustain an objection that should be overruled. As I was saying earlier, there's so many minor objections that happen during the course of a hearing. I can't be second guessed on every single objection. I might respond to 500 of them. So I can't have my co-arbitrator saying, oh, actually, Arbitrator Crosby, I think you should sustain that. That undermines the integrity of the whole process if we're bickering amongst ourselves and presenting this sort of disunity on that. So we have to respect, and I do this when I'm not the chair, I give the authority to that chair to make the call. And if I disagree with, some minor ruling, yeah, that question was compound, he should have sustained it, but he overruled it. That's just the way it goes. I mean, judges make those kinds of mistakes on minor things all the time. But it's important for when it's that the three of you know that when there's something important, that the chair will not just steamroll it, but the chair will say, this is something that I want to discuss with my colleagues. And I do that. This is an issue that I think we should take a break. I'd like to hear from you. And I invite them to, without them asking for it, I invite them to weigh in and give me their thoughts. So that's a very important part of the process.
And one thing that both of you have alluded to is that the chair sets the tone. And so, whoever is sitting in the chair, the tone sort of reflects who they are and who their personality is. And as Bill and Jill has indicated how they conduct arbitrations, not everybody, as you know, is like that, especially when sometimes you have the chair who is a retired federal judge or something like that, used to, deciding everything themselves. So, if there is some issues that you have maybe with the way the chair is responding or including you or not including you, that, you always can have a sidebar conversation with the chair to let them know your expectations with respect to how things are going to proceed. And oftentimes people are responsive. Oftentimes people do things just based upon how they do things, and sometimes you have to let them know that there's another way for something to be done.
Well, on that note, I think that's a great way to close out this panel discussion. On behalf of the Metropolitan Black Bar Association, especially the ADR section, I would like to extend my sincere gratitude to Bill and Lisa for joining us, giving us your time and your talent, for sharing all these jewels with us, best practices, and really breaking down how an arbitration goes, how arbitrators think. The comments have been glowing. People have asked for a part 3, so maybe we'll do another reprisal of this in some form or fashion. But and thank you all the attendees. We didn't lose anybody after the CLE code was given. So you're really interest here in staying. We really appreciate you doing this. And for somebody that asked, this is recorded and the recording will be available. So if you know people that are interested and that missed it, please invite them to watch the recording. And Jill, I'll let you offer any last thoughts.
Well, the only last thought I have is that I want to thank our other sections of the Metropolitan Black Bar Association that co-sponsored this program. So once again, I want to thank the Civil Litigation section on behalf of the ADR section, the Labor and Employment section, and the Solo and Small Firm section. I hope that you have obtained really good nuggets of information from our expert panelists, and we look forward to seeing you in the future for future ADR section programs of the Metropolitan Black Bar Association. Thank you, Bill and Lisa.
Thank you. Thank you.
Thank you. It's our pleasure.
Yes.
Take care.
Good night.
Good night,
Good
everybody.
night.
Everyone.
Bye.